Hey everyone, and welcome to another Explainer. Today we're tracking a really fascinating, incredibly high-stakes legal showdown happening right now in the Delhi High Court. It's all about Natco's patent challenge. If you follow the intricate, sometimes dizzying maneuvers of pharma law, you're going to find this absolutely captivating. We're talking millions in potential revenue, so we're going to break down the moves, the counter-moves, and the underlying strategy of this massive corporate battle.
But before we get lost in the weeds of the specific legal maneuvers, we have to ask ourselves a crucial question. Why exactly is the Delhi High Court stepping into this particular major pharma dispute? When the judiciary actually steps into a clash between a generic manufacturer and a huge multinational patent holder, it signals a massive conflict over market exclusivity. We're looking at a judicial intervention that could literally disrupt the status quo for a highly lucrative compound. So let's break down the mechanics of this dispute entirely objectively.
Okay, let's dive into this. Section 1. The court seeks answers.
Right out of the gate, the headline here is that the Delhi High Court is demanding a response. And this isn't just a polite request, it's a formal legal mechanism. The bench has essentially paused the clock, looked directly at the defending multinational, and given them a strict deadline to formally justify their patent claims against Natco's challenge. It creates an immediate, palpable sense of urgency. The defense is now legally compelled to provide substantive arguments, which completely shifts this dispute from a private corporate standoff right into an active, high-profile public face.
To see how we got here, let's break down the procedural momentum of this legal chess match. There's a clear three-step buildup. Step 1. A baseline legal dispute arises over the specific pharmaceutical intellectual property, centering entirely on market exclusivity. Step 2. A formal patent plea is filed. This is Natco making a highly aggressive opening move, officially placing their arguments into the public record to contest the patent's validity. And finally, Step 3, the exact moment we find ourselves today, the High Court seeks a response. The step-by-step progression shows exactly how a standard commercial disagreement practically forces formal judicial mediation.
Which brings us to Section 2, Natco's patent plea.
And this brilliantly illustrates the specific strategic intent we're dealing with here. A patent challenge plea is a formal legal request aimed at questioning, reviewing, or outright invalidating the claims of an existing intellectual property patent. But in this specific context, Natco is deploying it as a highly calculated tool. They're trying to clear the path for a generic alternative well before the expected patent expiry. If successful, a plea like this doesn't just, tweak a licensing agreement. It completely alters who has the right to manufacture and distribute a critical pharmaceutical product, shaking up the entire market share.
It all hinges directly on the core filing that sparked this whole judicial process, what's officially known as Natco's patent challenge plea. Natco is strictly taking the offensive here. They're building their case on grounds like prior art and a lack of inventive step. By officially lodging this plea, they are forcing the patent holder to rigorously defend the novelty of their blockbuster compound. It is a calculated, strategic strike at the structural integrity of the defender's market monopoly.
Moving right along, let's unpack this in Section 3, the dispute explained.
Now, what's really interesting about this dynamic is how clearly it defines the two opposing forces. We're essentially watching the scales of justice actively at work. On one side of the dispute, you've got Natco's offensive strategy. It's this intense push to scrutinize, cite prior art, and invalidate the existing exclusivity. And perfectly counterbalancing that on the other side, you have the mandated legal response. This is the defensive strategy, strictly required by the Delhi High Court to uphold and justify the patent's novelty in the face of all that intense scrutiny. It's a perfect, symmetrical balance of legal pressure and required reaction.
To really understand the foundation here, let's just quickly outline the baseline facts of this specific dispute. First up, this battle centers squarely on intellectual property rights for a highly lucrative pharmaceutical compound. At stake are millions in potential generic sales versus protected revenue. Secondly, these rights are being tested against India's incredibly stringent pharma policy and regulations, which notoriously set a very high bar for what constitutes genuine pharmaceutical innovation rather than just, say, a minor incremental update. And third, because the financial stakes are just astronomically high, it requires judicial mediation by the Delhi High Court. They have to step in as the ultimate, neutral referee to apply the complex letter of the law evenly.
And that leads us to the bigger picture. Section 4, Industry Ripple Effects.
So the crucial point is that this isn't happening in a vacuum. Rulings in cases like this actively shape policy and regulations. When the Delhi High Court mandates a substantive response in a high-profile challenge like this, it signals the prevailing judicial standard for patent scrutiny. The outcome of this isolated standoff actually has the power to dictate the macro-level rules of engagement. It influences how practically every other pharmaceutical entity is going to file for and defend their own patents moving forward. When we actually break down those specific ripple effects, we're really looking at three major impacts. Number one, a challenge like this stress tests the strength of current patents. It proves exactly how well secondary patents hold up against claims of obviousness. Number two, it sets the stage for future legal precedents. How the bench evaluates Natco's specific claims and how they judge that mandated response we talked about will absolutely be cited by litigators for years to come. And number three, it highlights the inherent tension in pharma intellectual property, that constant, delicate balancing act between protecting costly innovation and accelerating market competition.
As we wrap up this explainer, I want to leave you with one final, pivotal question to chew on. How will the required response ultimately shape the future of pharmaceutical patents? The defense is officially on the clock, the Delhi High Court is watching closely, and the entire pharmaceutical sector is waiting with bated breath to see the next move in this incredible legal standoff. We now know the strategy, the stakes, and the arguments at play. Thank you so much for joining me for this breakdown. Keep your eyes on the board, and as always, keep learning.